Welcome to Get the Facts. This is the program that provides you with information on government's policies and initiatives. I'm Theodore Henry. Today we're looking at provisions under the Bail Act 2022 relating to absconding, surety, failure to surrender, among other things. And leading this process is the Ministry of Legal and Constitutional Affairs, and Portfolio Minister Malahoo Forte will take us through some of the clauses and the intended outcomes. Welcome to the program, Minister.
You can tell that I'm always excited to speak about the law.
I can. So let's talk about some of those new things, in particular some of those that we listed.
So, everyone should know that the Bail Act strikes the right balance, even if I must say so myself. I've had the benefit of working as a judge. I have had to deal with grants and denial of bail over time.
Right.
I've worked as a prosecutor. I've also worked very short as a defense lawyer, and now I come as a legislator. So all of the experience I've gained and listening very closely to complaints on both sides of the case,
yes,
defense and prosecution, this new Bail Act strikes the right balance. So you hear people talk about, boy, they can't get records out of the court. This law allows for prescribed records to be kept. So any decision in respect of a grant or denial of bail has to be in writing in prescribed form, and that information is served on the defendant and on the prosecution.
So you don't have to go looking for it. It's served to you.
Not at all. And we have put it in prescribed form to allow for speed in keeping the record and for consistency and accuracy. And we have specified what must be stated in the record.
Right.
So any defendant who needs to show that they are on bail can have the record for themselves. Any defendant who has been denied bail will get the record to enable them to apply for a review or an appeal of it. And the law sets out very clearly where you appeal to from. So
right,
a decision, you can appeal from a decision of the police to the parish court to judge, from a decision of the parish court judge to the Supreme Court to judge. And now we also have the prosecution right of appeal, and the prosecution will appeal to the Court of Appeal.
Understood.
Couldn't make it any easier for you. You hear all the complaints. You can't get the records out of the courts. Prescribed
No,
form
it's prescribed. No,
in
it's
the Bail
prescribed.
Act.
No, I know you would absolutely tell everybody to go and read the act for themselves.
Fully and carefully. All laws are to be read fully and carefully. And as we review them, we will write them in simple terms, so laymen and women can read and understand. But if you can't, you can always ask us.
Yeah.
You know, it's the age of media.
Right.
But you recall I was telling you previously about the offense of absconding.
You were.
Just to say,
You were.
5 years imprisonment in the parish court, 7 years imprisonment in the circuit court. If you're granted bail, do not abscond. No, you have a duty to surrender to custody when you are given bail. Ultimately, you must return to stand trial or
right,
any stage of the proceedings to follow. But you know, we understand that sometimes you may be setting out on your journey and something may happen. God forbid you may have met in an accident and end up in the hospital. This new law gives you the benefit of the doubt. If you fail to surrender to custody, you're given an opportunity to surrender at the next earliest opportunity, because the date that you are to go back will be set in the record. And for any offense that has been created, you're given defenses under the law, striking the right balance.
Right.
So you know that when a decision is taken, let it not be said that the law was unfair to you. You have responsibility for your own conduct. No grant of bail is to be treated lightly.
I want to ask you about the engagement of the public in this discussion on the new Bail Act. What's the aim here?
As you indicated, and I reiterated, the law is being reviewed by a joint select committee of both houses of Parliament.
Yeah.
And we have advertised for persons to come in, read the law, tell us what you think. If you have had an encounter with bail and you want it to be considered, we send special invitation to certain persons. The Bar Association of the Jam Bar and the regional bars, the faculties of law, persons who keenly look at the law to see if they strike a right balance. But anyone may come. Anyone may come. Yes.
I don't have to be a lawyer.
We are trying to be as permissive as possible, though the review is going to be time-bound. But at the end of the day, we want our laws to be owned by our people, because laws regulate conduct and laws are there to protect. And bail is not an instrument of punishment nor of reward. Right. It really is saying that in certain circumstances, the Constitution permits you to be deprived of your liberty, even though it has given you a right to be free and a right to move around. But in certain circumstances, that right can be clawed back. And any right that you have must be responsibly used. You do not exercise your right to the detriment of someone else having a right.
And the government would like
you to
understand.
So you're not entitled to just walk around and do as you please and commit crime, especially if you have been charged with an offense. And by the way, let me tell you, the new law has revised absconding, and if you abscond bail, bail is denied. If you breach a condition of the bail is going to be denied.
Yes.
Revoked, in fact, revoked. And the offense of absconding carries imprisonment. And it will run consecutively to the offense for which you were on bail.
All right.
We also have new provisions in relation to those who will stand surety.
Yes.
And I'll just say that if you are a parent of a minor and you consent to standing surety, then you also are under obligation to ensure that the child complies with any condition of bail imposed.
All these
more
are contained in the bill. Minister, we're going to take a very brief break here. The conversation with Minister of Legal and Constitutional Affairs, Malahoo, Forte, continues on the other side of this break. We're getting the facts on the Bail Act 2022. Stay with us.
To deal with crime and violence, we must be united. Please cooperate with the security forces. Call 311-119 or the JDF tip line. If you know something and you not talk, you're a part of the problem.
Welcome back to Get the Facts. We are discussing measures being taken to strengthen our laws with special focus on the Bail Act. Still in studio is Minister of Legal and Constitutional Affairs, Malahoo Forte. So let's pick up on our conversation. While we were talking, you mentioned judge only. You mentioned different levels of bail, I'm sorry.
Right.
JP can grant, police can grant, and a judge can grant.
Right.
Are there any distinctions?
There are some offences. The law currently has it, but we have clarified and just added other offences. So at the back of the Bail Act, the new Bail Act, by the way, until the law is passed, is referred to as a bill.
Right.
And when it is passed by both houses of Parliament, it becomes an act and it takes effect. So there are schedules at the back, and you will see offences, you will see forms, and you will see offences set out. And we have in the second schedule, part 1, offences in respect of which bail may be only granted by the judge. For example, murder offences under the Treason Felony Act, under the Malicious Injuries to Property Act, and then we have listed a number of new offences under the new Firearms
Yes,
Act.
yeah.
You will also see offences for which you cannot get bail after you have been convicted. But you could only get bail after conviction if you were on bail before and you have lodged an appeal.
The reasons for bail or denial of bail that you mentioned would be served. Would that document have this information? The date?
Certainly. It would give you, if bail is denied, it would indicate the ground on which bail is denied, because the law sets out very clearly what the court must take into account, what any deciding official is to take into account. You know what we have also done? They say the best way to prevent abuse is not to invite it. And because bail may be granted not only by the court, but also by the police and a justice of the peace.
Right.
And in particular for pre-charge bail, we have specified the conditions that may be granted by the deciding official, who is a police or a justice of the peace. And then we have given a little more latitude to the court, where the deciding official is a judge, or any other condition that is thought appropriate. Striking the right balance.
Striking the balance. And you were speaking about liability for absconding from bail. You mentioned 5 years or 7 years as prison time.
Yes.
And I wanted us to actually
juxtapose
it.
After the time that you will have to serve if you are convicted for the offence that you were on bail.
But just before we talk about that, I wanted us to talk about what obtains before. So now you're saying it's 5 years to 7 years. Before it was...
you're going to get a fine, probably 12 months, etc.
Not so bad.
In fact, when we were preparing the law, I recall being told of how many files existed for persons who had absconded at the circuit court. And that is why the offence is also triable at the circuit court. But let us look on how we have struck another balance with the law as you get the facts.
Sure.
So you may be granted bail with a surety or in your own surety. That is when somebody else, vouches for you and is placed on the responsibility as far as possible to ensure that you comply with any conditions set. Such a person can apply to be released from the obligations of a surety, and the law sets out. And you will also be released after the case has come to an end if there is an acquittal or a conviction. And also if the case has been dismissed and a certificate of dismissal is issued. And just to say to everyone who is charged with an offence, if you go to court and judge throughout the case, make sure you get a certificate of dismissal. The law provides for it in standard form. Many do not get it until they are applying for a police record and something shows up.
Right.
We have indicated that, we have pointed out that a certificate of dismissal exists. And if you stand surety and the person has been acquitted and is issued that certificate of dismissal, you would be released of your obligations as a surety. And there is also another circumstance in which the Director of Public Prosecution may stop the case by issuing what is called a nolle prosequi. If one such is issued, then, and you stood surety, you would be relieved of your obligation. The law also has new provisions around the property that can be used for surety. Can't use the same one over and over unless the court permits it and unless it is of sufficient value to cover the sum of the bond.
But that's interesting. You say we can't use the same one over and over as in
it's a lot of rascality that's out there,
So do you mean I can't use this surety for this case and then that case, or I can't?
Because if there is a breach, there is a liability for the surety to be forfeited. Clarification in the law. Let me tell you, when we strike the right balance, we're also closing the loopholes. So, what can I say? Read it fully and carefully. And if you have any questions, I'm on Twitter. You can always DM me. I'm on Facebook. You can send a query to the Parliament. We'd only be too happy to answer any question that you have.
And my final question, for those who are invited to come and read the bill and give their feedback outside of digital channels, are they to come to?
You can send, if you have read the Bail Act 2021 and you have a comment, you can write to the Parliament and you can send that comment to the Houses of Parliament at Gordon House, Duke Street.
All right.
But like I say, the whole goal is to ensure that people know the law, that they take ownership of the law, that we who are passing the law, because we're your representative in the House of Parliament, and the Parliament's primary function is to pass laws for peace, order, and good government. So we will listen to you. Your lived experience matters. And at the end of the day, our aim is to move Jamaica from lawlessness to lawfulness, from chaos and disorder to order, to ensure that we can all enjoy this piece of paradise that we're gifted with as our island home. So, hope you get the facts. And if there's anything else that you want to know, feel free to contact me. We're in Parliament and your Parliament is televised. Or you can come to JIS.
Why not?
interviewer will only be too happy to pass on the information.
Absolutely. It's on our website, it's on our YouTube, or if you would like, you can come here as well. This has been Get the Facts. Our guest has been Minister of Legal and Constitutional Affairs, Marlene Malahoo Forte. Again, you are encouraged to read the bill for yourself. You are invited to make your comments and your submissions. And we want to thank you for watching. And until next time, I'm Theodore Henry. Take good care.